So everyone, please welcome Kamil. Kamil is talking about the need for a legal framework in lunar industrial development. So off to you, Kamil.
Okay, thank you very much. Greetings, and well, here we can say good evening, as it is nearly midnight here in Poland. So my name is Kamil Muzyka, and I am a PhD student at the Institute for Law Studies of the Polish Academy of Sciences, and also a co-host of a website called Prawo I Kosmos, the Law and Outer Space, which logo you can see on the first slide. The subject of my presentation will be the need for the legal and industrial framework for the lunar industrial development. This would consist the idea of resources, products, objects, and space debris, or even space wrecks or space junk, more adapted and more suitable to a lunar industrial environment. Let's start with one simple quote. "The world is no more closed than it is flat," by Kraft A. Erike. This is a thing that should be always considered, not only within the terrestrial biosphere and economic sphere, but also in the lunar and the outer space sphere, as we can always see that all celestial bodies are in a state of a perpetual dance or a motion within our galaxy, or even simply our solar system. The moon is actually a very little dot that orbits the Earth, but essentially for us it's the proving ground for many space technologies that are to come. And if we actually want to settle on Mars, or even travel to the outer reaches of the solar system, we need to improve our technologies, especially around the cislunar zone, or for example, if we, for example, want to use space resources, we need to define what are those space resources, and create some kind of some new technologies and sustainable means for utilizing them. And the question is, what are space resources? Well, first thing, the classical understanding of space resources is that they are abiotical resources residing within the celestial bodies or their atmospheres. I added atmospheres because it is the old idea, for example, for mining hydrogen or helium-free from the Jupiter atmosphere, which is not unlikely, although we currently know how can we actually get helium-free otherwise than mining in Jupiter or Saturn. However, these are mostly abiotic resources, so any kind of life form we find will not be used as a space resource. However, we need to recall one thing. Abiotic does not mean non-organic. There are organic compounds within within comets, on asteroids, and even we have hydrocarbons in gas giants. So that is not to say that we cannot mine or utilize anything that is organic in origin, or even closely similar to compounds we actually find on Earth. It's only that they cannot be living life forms. So these are mostly minerals and volatiles and isotopes. As we can recall, space law and most space legal frameworks or proposals do not count even those amino acids and alcohols that are found in our space as space resources. We mostly focus on minerals, metals, or regolith, volatiles like water ice or hydrocarbon ice, and also the isotopes like the famous helium-3 isotope, which is actually being planted into the moon by the solar wind and other factors, and it's not growing there. I think I have to actually state that, because I found it that some space lawyers actually still think that helium-3 grows on the moon. So that is that. And also we need to recall that in this classical understanding, the classical legal understanding, neither the solar wind nor stellar radiation nor the interstellar medium are even considered space resources. And still we have to ask ourselves, okay, so if these aren't space resources, what is a celestial body? Well, a celestial body is, like Virgilio Pop said, a celestial body is a celestial body that is a celestial body. That was the title of his article about the ambiguity of the term celestial body. Anyway, well, there isn't a strict term for a celestial body in the body of outer space law. However, there were some ideas to regulate the concept. However, we still need to recall that in order to create a stable space law, it needs to be less less sensitive to any impediments that or shifts in science, like new discoveries or new policies by the International Astronomical Union or other body or other scientific central bodies, which can actually create new concepts. For example, in the times where the Outer Space Treaty was being drafted, there was little to no idea of what a centaur is, and not many people were interested of what actually the comets are or where do they come from. Then that is actually the problem. For example, do Kordylewski moons or are Kordylewski moons actually celestial bodies? These are the cloud moons that actually surround Earth. Surround Earth. They orbit the Earth at Lagrange points. So are they actually a celestial body or a group of celestial bodies? Can we mind them or not? Are they covered by space law or aren't they? Well, that's a conundrum, but that's for another day. However, this is a problem here that we can see, that we have space resources actually are being looked upon as valuables. What do I mean by valuables? Some people actually still create those pitch decks or presentations where they actually make business cases for asteroids with platinum, with the use of the platinum group metals, with helium-3 or with rare earth minerals. Well, the idea is great because, well, you have to make a business case in order to make it feasible. But that is not actually the case for a sustainable industrial environment, because the industrial environment is much more than merely those this little group of valuable minerals and materials. Also, the moon is sometimes considered an eighth continent of Earth, and it is both rich in resources and being actually seen as this new scramble for Africa with all those gold mines, with rich minerals, and everybody is out to grab and outrace everybody else. Well, that is not exactly the case in my point of view, especially if you consider what is on this picture. And on this picture, it's a Moravec bush robot. Well, bush robot is a fractal robot that in in a hypothesis, because it's not a theory, could not only create the smaller and smaller appendages of itself, but also could replicate itself. There were ideas of self-replicating space objects, but self-replication is a far-off thing. The thing I'm interested in most is actually creating things on the moon using space resources. For example, like in this idea of the self-growing lunar factory, which was a part of the NASA's study called Advanced Automation for Space Missions from, I recall it was in 1982. These ideas actually are focused not on only on creating value by extracting rare earth minerals, but actually creating an ecosystem in which robots create other robots, and these robots actually work as a form of ecology. In order to actually understand it, we have to understand one thing. For example, in order to mine something on the moon, we have to have some techniques for extracting the resource, but also in processing the resource. It's something like the pioneer organisms on Earth did. For example, we cannot grow plants on the moon because they lack the proper soil. And what is the proper soil? The proper soil is the one which actually was being inoculated with bacteria, which were the pioneer organisms, and they actually changed the makeup of the soil. So in this way, these robots actually would need, in order to create their own ecosystem, would require to create their own industrial ecosystem, so they would be able to actually use those resources on hand, so to say. Well, there were also ideas, for example, for things like the Santa Claus machine, but the Taylor Santa Claus machine, but we know today that, well, although the Santa Claus machine is a far way off, 3D printing and other forms of additive manufacturing are underway, and they have been tested on the ISS and other objects. So they are being actually studied as to be used for space applications. But in this case, my question is, what is the legal status of a thing created by a thing, an object created by by another space object, or is it actually an object? You see, although there is a old science fiction and futurist concept of the von Neumann probes, which are actually not von Neumann, so to say, because John von Neumann never spoke about space probes, or even never spoke about machines that could eat themselves through rock and replicate. Anyway, the idea still holds, and the name still holds because of, as I recall, Frank Tipler actually called them as von Neumann probes, and well, science fiction authors took it and ran with it. But the idea that machines could create other machines on the moon is actually something that is very interesting to us, because in order to have a sustainable lunar environment for machines and ecosystems and the industrial applications for even the cislunar ionosphere or the geostationary orbit, you actually need to have it as sustainable as it goes. So most things won't be launched from Earth, but rather created in outer space. But can, in the legal sense, a space object create another space object? Well, this is a tricky question because it was never answered. Well, there is an idea, but let's keep to the point. First of all, most of things that will be produced in outer space and mostly on the moon should be considered space products. Even the Hague work group, which actually created its own definition of a space product based on the space resources, has actually created their own also idea. Well, I was part of the observer team and I suggested several things, so it's not to say that it's my idea, but it's part of my partly is my contribution that they actually regulated the idea of their own idea of space object, which is made and composed of partially or wholly of from space resources. In this manner, however, we need to actually ask ourselves, okay, if it's a space object, it's not a product, because, well, there were ideas of robots like Moore's artificial living plants, which weren't space-based, they were ocean-based ideas of extending the von Neumann idea, but actually they would extract those resources from water and create other crafts and also help the local communities in Africa and other developing nations. Well, this wasn't a very great idea, which also Freeman Dyson has developed further. But we need to recall one thing: these all are just futurist concepts. However, the idea which I am talking about, that space objects can create space objects, has been actually addressed in the proposal of the HR 3610, which is to be called, in short title, the American Space Commerce Free Enterprise Act of 2019, which is still sitting idly in the Science Committee of the Congress. However, as we can see here, what is a space object? The inclusion is that such term includes any human-made space, any human-made object that is manufactured or assembled in outer space and intended for operations outside and independent of the objects which the manufacturing or assembly has occurred. So in this sense, actually, space objects do create other space objects. And what does this imply? Well, with Article 7, we can actually, it was the Article 7 or 8, I'm sorry, I forgot, but the space object nations do retain the jurisdiction of the space objects which has been launched and carried within their registry. The idea here is that any object that has been created by such space objects, no matter the material it was created from, will also retain the jurisdiction of its mother object. This is what I call the von Neumann doctrine in one of my works. It was the Space Manufacturing and Trade paper published last year by Astropolitics, and it's also part of my PhD where I actually address the issue of machines making machines, and also have created an additional doctrine, which is called the Hermit Crab doctrine. The Hermit Crab doctrine is something different than the von Neumann doctrine. The von Neumann doctrine states that unless parties agree otherwise, any object that has been created in outer space by a space object is retains the jurisdiction from its mother object. The Hermit Crab doctrine states a different thing. If an object absorbs parts of other objects, for example, in the case of repairs or reconstruction, of an object, these elements are being absorbed into their body and being treated as their jurisdiction. I usually use an analogy of a robotic rover. A robotic lunar rover which has a broken wheel. A broken wheel which, well, if it doesn't move and it actually makes it difficult to for the rover to actually to perform its mission. But anyway, there is a case here. The rover cannot repair because it doesn't have the spare parts. However, there is a different rover that is standing out there. It's a foreign rover. So under Article 12, if it's for example, a space debris, well, it's treated as space debris or space junk because it is inactive, it has a broken battery or something else, but the wheels are working. And these are the same wheels or similar wheels that can be utilized. The operators or the AI can actually ask for permission to use those wheels. Okay, so if it gets the permission under Article 12 to use the other space objects, and it's a dire situation, which has been also covered within the Moon Agreement, but well, as we know, the Moon Agreement isn't currently being discussed in the United States as a body of law. Anyway, if it gets and attaches this wheel, if it's is it a foreign object then attached to the original object, or is it a new object, or is it a object that is being introduced to this jurisdiction and becomes a part of this rover? Well, for all means, let's say that if it's a part of a well, if it becomes becomes the part of the rover, well, we need to take one thing in mind. We need to have one thing in mind. Okay, take into account the thing that if any damage is being done by the rover to any other party, the one who actually still retains the jurisdiction over the attached wheel could also be sued. So it's better to give away the wheel, and also this is makes many other things well, more simple, and also has its own meaning and reason in the patent law. So anyway, why are we discussing the space debris here? Well, the space debris, here we should actually say one thing. If we shouldn't think of many things in our space as waste, but rather as byproducts. And how can we reutilize them in order to make it sustainable? We know how we actually damage the environment by making our industry unsustainable and being contrary to the biological meaning, well, the biological I don't want to say philosophy, but the mechanisms for extracting resources, like for example, plants extract resources in different manner than machines, but also plants can replicate and plants can repair. And also they can decompose and become parts of other plants if they are no longer useful. Anyhow, there is this idea that, for example, many space objects can be utilized, even if their mission has has ended. They can be utilized by other space objects. As I gave the example of using that wheel as spare parts, or even materials for being for shielding and so on, or even a modern art masterpiece if we actually wanted to. But we have to keep in mind that in some states, like for example the United States, within the Artemis Accords, added the idea of the heritage. so that some space debris or space junk that is a leftover from prior missions that no longer serves any purpose cannot be recycled or being reused for spare parts by any other party, because it's declared a heritage site. And we also need to take this into account. Also, the one thing about Artemis Accords that actually I find wonderful is the integration, is that all those elements should be integrated. That means that there needs to be a standardized parts. So in any way, they would actually be able to reuse those parts from those rovers, and that needs to be also regulated on a similar basis, because we also step into the field of patent law. And patent law, as we all know, is a very tricky field, and well, a very violent field. It's not a divorce law, for example, but it's also a field where actually NASA has some some legal cases that are actually being taught to patent lawyers are involving NASA. For example, NASA versus, well, it was the Hughes aircraft versus the United States, but it was actually against NASA's Goddard Space Center. Anyway,
hey, Kamil, sorry to interrupt. We're actually at the end of the allotted time. Do you want to jump to questions, or do you want to wrap up your
okay, so I'm going to wrap up. So the last thing I wanted to present to you, it was the idea of are we going to have living space objects? Because, well, there is a blurring difference between the hilo technology and biotechnology. But anyway, to wrap things up, I would have to I will have to write a article for the Space Review to actually describe the idea that patent law will be, well, not an obstacle, but actually another pillar of the space industrial law, especially in the case of self-replication, but not only replication, but repair, reconstruction, and other concepts like, for example, the extraterritoriality and the effectiveness doctrine. So we can actually go to questions here.
So Michael did have some questions in the chat or observations. So Michael, now's your opportunity.
Sure. So in the many things that you were discussing, why don't existing legal frameworks around salvage rights, property extension rights, if I have a robot factory that uses a robot to make a robot, no matter how many iterations go through that, those robots all belong to me because it's my factory and my robots. Those are well understood concepts in property law that go back thousands of years. And same goes for salvage laws. We've dealt with salvage on the high seas for many years, and we've come to an understanding between all the nations and all the people about how to work with that. Space may have a few additional special properties to it, but none of those properties cause human nature to change. Where does the impulse come from to view law in space as a tabula rasa where we get to start over?
Well, the problem is that they were developed in different times. For example, maritime law has a longer heritage and longer history of actually their from the age of sail and further the salvage, the jettisoning, the idea of saving other sailors. And these were developed historically, whereas the international space law was, well, it borrowed many things from the maritime law, but actually it had to deal with the concept of preventing the outer space from becoming a new battleground. So that is the problem.
Sure, and that I understand the origin of the Outer Space Treaty, but why does that negate all existing law?
No, it doesn't negate the existing law because, for example, if you retain the jurisdiction over space objects, for example, as I said, space objects making the space objects, they retain jurisdiction. If you're a US citizen, every US law applies to these objects. The only problem is when they intersect with other, for example, Chinese or, for example, French, German, Russian, Japanese, Brazilian space objects. These are the cases where we actually have to decide which one actually caused damage. And for example, in the patent law cases, for example, which one is actually being, for example, you have a space station and a space object, a shuttle or any kind of a robotic space object that docks into the station.
Right, but why is any of that different than an American boat in the middle of the ocean or even somewhere else? I mean, we have existing courts and methods for dealing with tort law between nations and citizens of nations already. There doesn't seem to be anything special about the fact that that may occur in space versus on the high seas or within the national borders or anything else. I mean, the case law and the process for dealing with those conflicts seem to be fairly well established already.
Well, no. High seas and outer space, yes, but not territory and high seas because they are quite different things. Because what you're doing on the high seas, you're still under the jurisdiction of your state, but there are other mechanisms involved. Here, for example, in outer space, you cannot claim land for yourself.
But you can't claim land in the middle of in the high seas either.
Sure. But that's quite different from, for example, the Westphalian idea of national territory and borders.
So are we throwing away national territory and borders? So my concern is that human nature does not change. But for some reason, we do seem to think that human nature in space is different.
Yes, there is a problem with the idea that humans in outer space should behave differently, and that humans won't, for example, mine things for profit or game the system for profit. That is the most frequent challenge to any space law model. If you don't take into account what people will do, then you either throw out the baby with the bathwater, or actually do nothing and create a hostile investment area where no property is being protected.
But that's the thing is I run a space venture capital fund. I don't need 100% of property rights in space to be able to do business in space. But if we have to spend the next decade contemplating an entirely new legal regime before we can go, then that is something I won't invest in. For example, sure. In the call that we had yesterday, where the suggestion was the U.S. National Environmental Protection Act would apply to any action by any U.S. citizen in space, and that I would have to do an environmental impact study every time that I actually wanted to do a mission, that would effectively shut down the space industry. Full
sure.
stop. And so I am, as I see in some of the discussions within Copulus and UNUSA, and even for the most part in the Hague, the Hague Working Group products were a reasonable place to start, but whenever we talk about the treating space differently, I really wonder why that motivation exists. And I would strongly suggest that if we actually want to go in and do things beyond the Earth, reinventing entire legal regimes first is a way to never, ever actually go.
Yes, this is the problem with the international space law, which wasn't actually designed for a thriving space economy or civilization, but mostly to keep the superpowers in check.
Right. It was designed to stop things from happening.
Yes. For example, the idea that there is a non-appropriation principle where you cannot claim sovereignty or property rights via occupation or any other means, which includes the old American idea of homesteading, which was which is still being seen in many circles. I say the Moon Society, but I recall discussions in the L5 society, not the L5, the NSS, being where the idea of space homesteading is being rediscussed.
Yes, and and that's where, while there are good parts of the Outer Space Treaty that I fully support, I am hopeful for the day when the OST itself is tossed and we can get rid of those particular provisions, because my personal goal is, and the goal of many of the companies that we invest in and the people, at least in the space industry that I deal with, the goal is to go into space and never ever come back, and to leave the Earth behind permanently and forever. And part of that motivation is to escape this morass of laws and stuff that we have to deal with down here. So, sorry, that's just my personal kind of motivation for being involved in this industry from the start.
Well, you need to recall that if most of the activities, industrial activities on the Moon, will be carried out by robots, you need to recall that in some points, robots programming will be far better than any other regulation. Because, well, why do we need regulations? Because we want to stop some things from happening. Because we have to have checks and balances on people.
Yes, but all of our laws about conflict and regulations, at least in the US, are based on demonstrated harm. Demonstrated, not perceived, possible, imaginary harm. The best law is the law that is discovered, not invented. And I think that we are spending a lot of time, a lot of people are inventing law that will never apply to them.
Well, that's the problem, for example, with the Moon Treaty, which was the most science fiction-y space treaty. Well, it covered the environmental impact, it covered lunar resources and all sorts of stuff, and also threats of violence against spaceships. It looked like that old Arthur C. Clarke story, the Earthrise.
Right.
So, and we all recall who actually stopped it from being ratified by the US. A group of futurist engineers, scientists, and science fiction nerds. So
yes,
that is what you get for creating such treaties.
Yes, and so I guess I would, to go back, that's one of the things about the Artemis Accords that I am happy to see is it is a way forward, and it is outside of the UN.
Sure.
Because from what I see in a large amount of the conversations within Copulus is people creating rules and legal regimes that will never apply to them. But so therefore the consequences to them are zero.
Well, the problem is that, for example, in the UN Kopuo, also many nations, I'm not saying that it's bad that nations have something to say, but sometimes the power play between nations is like, for example, Russia never signed the Moon Agreement, but always plays the good guy by playing the Moon Agreement card and always
Yes.
trying to berate the United States or the Hague Work Group or any other state, maybe even the UAE in the future. Oh, the UAE actually made a very good move with their own national space law.
Yes.
And that is also something we are trying to do in Poland, but first we have to create our own space legislation, and it's taking forever. It's something like 8 years now, going back and forth, because some people are pro-EU, the pro-European Union factions say that no, we should actually leave it to the others and step aside. But they also want us to actually adopt the Moon Agreement. So yeah, that is that, because they think, well, once the Americans start mining, the money starts raining down through the UN. And no, that is not going to happen. We know how it is with the high seas and the UNCLOS treaty.
Before we go, can I ask a question?
Sure.
Sure.
Okay. My question is about the developments, the technological developments on surveillance systems, especially, and here in Earth, here on Earth, we see a lot of violations in recent years by use of these surveillance systems. And do you consider that are we gonna need some new regulations to protect human rights which are vulnerable, as like the right to privacy or the right to respectful private life, which are violated so much in our new surveillance era? And I wonder what's your thoughts about it.
So I can give you a quick answer. If it would consider the moon, the problem is, have you ever read the book Lunar by Ian MacDonald? It's a science fiction book, but I highly recommend it because it answers in one way your question about the surveillance and data mining and human privacy, where it is non-existent on the moon, where every breath you take, every sip of water you make is being monitored. Your hormones, your everything is being monitored by the system. So probably there is going to be a lot of data mining and a lot of surveillance on the parts. Also at the Hague work group, the idea of the safety zones was also being discussed as a radio shielding zone, so nobody can spy on a foreign space object or even hack them. So in some manner, yes, this will be an issue, but to be, well, I don't want to be the messenger who brings the sad message, but I think that first and foremost, the trade secret and the industrial espionage part will be the first one addressed, and later the human rights part.
Okay. I see that, but it sounds to me in the isolated societies in the future, these rights, these core human rights are these core human rights seems so vulnerable in the next years, next future. That's all. Thank you.
I'm going to jump in and at least provide an opinion. I do think, for example, even the UN agreement on human rights are still, in many cases, up for interpretation within the countries that are even signatories to that. And so, for example, we have, in the US, we have a different understanding of privacy and free speech than a lot of other countries. There's some interesting differences between the US and the UK on things that you can say and how speech can be criminal in one and not criminal in the other. And I do think that one of the unique features of space is that there is enough room that people can choose to live different lifestyles in different ways without affecting anyone else. And so there is the opportunity for people who have very, very different views about how human society should be organized have the ability to do that on their own without impacting anyone else. And I think that is something that we should preserve. Yes, there are basic human rights, but I think that across the world, some cultures interpret those human rights very differently. And if we can actually cause a lot of conflict, unnecessary conflict, by assuming that for some reason space is different and that one culture's view of how those human rights are expressed may dominate others. And so I think that, as I was kind of alluding to with Kamil, is we should resist the idea that human beings become different or think differently or become better somehow when they're in space versus when they're on the surface of the earth. And that somehow we can create a utopia in space is a good way to create a lot of conflict. Because one person's utopia is another person's hell.
Yes, but lastly, I would like to say that we shouldn't sacrifice on our human rights for any profit, commercially, or any profit.
But it but so can I by choice sacrifice one of my human rights?
Can you choose sacrifice?
Yes.
On your human rights?
Yes.
I would say that it's your choice.
Okay, that's fine. That's all I'm asking is give me the choice.
Okay then.
Sure.
It reminds me of the old works of Gerard O'Neill and the late Timothy Leary, who actually advocated for different societies to be created in various space communities.
Yes.
Where actually you would actually, if you want to live in a, for example, a free society of, well, not to say hippies, but for example, in a religious society or a non-religious, a libertarian, anarchist community, and so on, you can pick your space settlement where you want to live. Like, for example, you had the Quakers in the United States,
mm-hmm.
who created their own communities.
Yes, that's what I'm advocating for, because I am very worried that we are creating on the earth a single culture. And if you, it is very, for groups of people that don't fit that single culture that we are building here, that is very oppressive, and they will fight back. As that monoculture that we are building here squeezes out the ability for people to live different ways. And I think that's one of the values that space gives us, is the ability for people to go off and do something very, very different.
Sure.
And second, lastly, that I would say that one day all people, all entities, all parties can need justice, and you can guess which day is it gonna be. The day you will need justice or law regulations, legislative regulations, can be nearer or far than today, but I think that we're all human, and all human beings need justice.
Sure.
That's all. That's all.
I agree, but I do think that justice is very culturally dependent. For example, as Kamil may have figured out, I am very libertarian, which I think in the European definition would be classically liberal,
Yes.
and bordering on anarcho-capitalist. So my definition of justice would be very different than someone living in a left of center socialist oriented community. And so therefore I think that just as we have different definitions of justice in different countries, I do think that justice is something that we need to preserve the ability for people to choose the judicial systems they choose to live in.
Yes, I am trying to say with justice, my point of view is not related to any state, any government, or any nation. Just it's philosophically justice. That's all my things.
Sure.
Thank you so much, Mike.
In a world where we have people throughout the solar system, and that's what I'd love. I'd love for us to consider the solar system as our home, right? And then we're free from the gravity well, and the solar system's our home, not Earth. But in a situation where you have people throughout the solar system on the moons and whatever, I think it would be fairly, regardless of what legal system has been adopted, I guess, legal framework throughout the solar system, I think it's going to be fairly tempting to just ignore it, right? Like when you're on some moon of Jupiter and some law says you can't do something, who's there to enforce it? You got, someone back on Earth made some rule, and you're going to be like, screw those guys, I'm going to do whatever I want. And realistically, no one's going to come and enforce that. So I think it'll be pretty interesting. I don't really know what to do about that, if that's a bad thing or a good thing, but
even Vladimir Mandl in 1931 in his paper called Das Weltraumrecht, and it was in German, he stated that the farther you go from Earth, the longer it takes for the law to actually catch you. So there would be communities with their own laws and their own traditions, cultures, and so on. But for example, if it would come to meeting with two space cultures, being both an extension of the Earth culture, but living on separate space stations, we could actually assume that Andrew G. Halley had an idea, and also Ernst Fassan, about the meta law, the philosophy that was actually created for any contact with extraterrestrial civilization, and no, not UFO. Halley was actually a sound lawyer who was very contributing to the international law, although he was very anti-proprietarian, to say the least. He said that, well, if there are other beings in the in outer space, why should we actually claim other planets as our property? And there were many people who were discussing this. I even published a paper at Paladin. It's a journal of robotics, because I was addressing the issue of human-AI relations on the basis of Halley and Fassan's meta law. And I present there those viewpoints.
Well, seeing that as I fully intend on enhancing the mind with AI augmentation, the boundary between AI and human probably gets very blurry in the future as well.
And that's our only chance, Michael. Otherwise, we'll be subservient to the AI, and we'll make all our decisions, and won't know why.
Yeah.
That's my biggest fear.
That's why I'm going to be paying really close attention to Elon's update on Neuralink coming up soon.
Well, there will be many cases, for example, for robots actually performing their jobs and causing damage to property or people on the moon and other celestial bodies or in outer space. And these things also will be addressed by law or the lack of law, for example. I sometimes find it difficult to believe that both the transhumanist and AI enthusiast circles are so far away from space, from the space circles, and vice versa, that people that talk about space law don't take into account the developments in AI law.
I've seen the same thing. The Venn diagram has very little in common. A good company to take a look at is offworld.ai. They are building autonomous hive-oriented mining robots, and they're currently doing experiments in African mining sites, where the goal they're working toward is 100% autonomous, as in no humans are allowed to approach the mine within 1 mile of the mine. And the robots are fully autonomous. If they break, they cannibalize from each other. So if you take it offworld.ai is their website. They are getting significant interest from mining companies, because about 60% of the cost of running a mine is human capital. So.
Thank you, Michael. I just found their website, and we'll be researching it tomorrow. Well, as far as I recall, there was a case for autonomous mining haulers with Komatsu and their mining haulers, and also there were those perf mines where they used those remote-controlled bulldozers. Michael, you're on mute.
I think you might have disappeared for a little while.
Okay. Yeah, but that's a great thing. I didn't know about them. Well, the problem is that currently I just passed my chapter in my PhD on robots replication manufacturing. So, well, I don't want to go too deep again, because I need to finish my all other chapters, like, for example, the extraterritorial reach of patents in outer space.
Great.
Which is a very difficult thing, because it also involves the idea, for example, of solar sails, or actually laser sails and any other beam propulsion concepts. For example, what's the effectiveness doctrine? For example, if you're using for example, there is a French laser based in France that is being used to propel a light sail, which is an American light sail. But the French company doesn't have the license, and the patent isn't protected in the European Union or even in France, literally. Then we could actually use the idea, well, the precedent from the NTP versus Research in Motion case from the 2005, where there is the effectiveness doctrine. The laser, which propels the sail, would actually be used, and the effect of this use will trigger an infringement suit. Even though they are based outside of the US, the effect is on a US space object. This is also, there was the DECA case, and also the, as far as I recall, it was the LORAN. Yeah, the LORAN, it was the LORAN system, LORAN and Omega, the terrestrial navigational systems pre-GPS concepts. Well, the pre-GPS with literal radio masts on, as far as I recall, it was one was in Norway, two were in the US. Stuff like that. Over the Atlantic, they were placed over the Atlantic. And anyway, one guy was using a part of the system, but they had a impact on a US vessel, so he got sued because, well, it was part of the system. And it was seen by the US courts as infringement there. So in any way, this could also have an impact on the lunar industry and also the space industry as a industry of products and services that being based and used off-world.
I'd talk about off-world AI is pretty interesting. I actually have an opposing model in my head about how we should approach robotics than AI and off-world. Off-world, I mean, it's very, very impressive. I wish I'd work there if I could. Off-world, they seem like they're building the robots, and according to Michael, they're doing the full autonomy from 0 to 100. And I see that is an incredibly, it's a huge amount of work, and plus you're constrained by the linear ability of your company to scale the robotics. Whereas there's so many people in the world that are building robotics and doing hard shit. Like they're doing the machine learning, they're doing all the hard things. And I think that's going to be commoditized, right? So I want to take advantage of that. And I think if you build a platform to take advantage of the commodity AI or the commodity robots, and then you build it in a way so that it focuses on real-time intervention rather than sort of procedural, right? Because you're always the problem we have at the moment is lots of people work on hard things to build robots, but they're not useful until you build all of that. So you've got to go from like 0 to 100 and invest all this work and all this money to get to a point where it's useful. But there's lots of robots that are available now that I think you could capture some of that value that's already been created if you have a mechanism to easily intervene into those actions of those robots. So you tell them to do something, and you have to have the ability to quickly and easily correct course on that thing if it's doing something wrong. And then it's just a matter of building on macros on top of macros, I guess, right, or procedures to keep creating abstractions until you're in a place where like HAL 9000 is in control of everything. But that way it allows you to, initially you might only have, one person controlling 5 robots, and over time you have one person controlling 100 robots kind of thing, right? but this is all nothing to do with legal stuff. It's just what Michael was talking about got me excited.
Well, it will have to, it would actually be, it shall be discussed in the legal circles, because, for example, you know the idea of the innocent infringement in patent law? It comes from a stupid case. It was Monsanto v. Schmeisser, the Canadian case, but it also proliferated through other jurisdictions. The idea is that if you possess a means of production, but you are not aware that it can recreate an invention which you are not authorized to make, or a process that you are not authorized to perform, you are still liable for infringement, even though you haven't ordered the means of production to do it. It's a case from, of course, Monsanto. It's a seed patent, but for example, if you have a robot that would actually start printing or assembling or doing anything that it might view via its software, and that is possible, feasible, or required to perform its action. But for example, you don't have a patent lawyer on board, because even space lawyers don't mostly do patents. There is also a case for infringement, and also the cases for jurisdiction and so on. For example, there are also cases with robots proliferating over other bases. Like, for example, how do you, well, you have to actually be careful of what your robot is doing, and you're always liable for any damage it performs. And also, is it and also, the case, for example, robots disassembling anything. For example, if it doesn't get a signal, wait, that's not a space debris, that's actually still operating, that's like it might dismantle other things. Of course, that's a fair generalization, but also, well, we need to recall that outside of the lunar sphere, robots which are actually used for space debris, deorbiting or as space dogs, can be also used as a form of weapon. You can actually deorbit a fully functioning satellite. Well, you have to keep it in mind that that your space drive is your main weapon in outer space. And also anything that can disassemble rock, assemble, or has engineering tools can also be a weapon.
Sure.
So
I mean, most things can be a weapon.
Of course, and well, you would have lawyers literally swarming over the field if anything happens, or anything might happen. But the problem for me is to create a Goldilocks zone of the law. That is the issue, to not be underregulated and not overregulated.
So in the case of a robot doing something that violates some law, I mean, the robot's a property of someone, right? And wouldn't it be fairly straightforward that the person that owns the property that violated the law is the person that's responsible for the breaking of the law?
Sure, but also in outer space, as Michael pointed out, and I agree with his pointing out that we treat outer space fairly differently from from Earth. For example, you have different jurisdictions. Your American robot can actually enter a British jurisdiction of somebody else's base. and well, the claim for damage, the claim for is it breaking the law? I don't know. Should I tell the joke about that we had about the Russian national law and U.S. national law? But it was okay. So I want to actually delve into this part, but just to point out things. There are some things that are criminal in one state and are perfectly legal in other states. So we have to keep that in mind. And in the case of the ISS, you have the agreement which actually states which law is being, under which law falls every the component and the space object, the part. And also, how can you prosecute somebody for breaking the law in on board of the ISS? But it is only the ISS which has this kind of agreement. We may actually see different agreements within the further developments of the Artemis Accords and other space objects, because I do not exclude that, for example, there will be other private ventures which will also have to go into contract, which would actually write down every possibility. Like, for example, if you enter a hotel room and there is a big sheet of regulations which says no smoking, no this, no that, and something like that. Well, you can actually see similar things, for example, of sexual harassment cases. It's a perfectly thing. Humans are humans, and we know that we have to fight several problematic things that are still being well included in our lives and in our systems of society. But in this case, for example, okay, robots aside, the problem with jurisdiction is when you cross jurisdictions, and also that the moon is not a jurisdiction of itself, but it will be a patchwork of jurisdiction based on the makeup of the space objects that are on its surface or in its subsurface. So this kind of zigzaggy patchwork of jurisdictions will be a very difficult environment for not only lawyers but for simple business people or tourists to actually exist within or take any action within. For example, one thing that I don't like about space tourists is the idea of the stupid tourist. That's my personal generalization, but the idea of the stupid tourist is as follows. You have a space tourist who paid for the ticket to get on the moon, and he's going to use the full ticket. He's going to have fun to the full. And you have to actually, if you have astronauts, they know one thing: safety first. Don't put your hand where the mechanisms are. And what about the tourists? Well, you have to keep the tourists away from the mining equipment, from the smelting equipment, and from any other rovers, and even from the landing sites. You have to make it not only safe, you have to keep everything safe from him, from the tourist, because I know that's a generalization, but you have to keep in mind that there are some people who actually made some legal precedents. Like, for example, do you know that some baby strollers actually have a label that says that you need to check before how do you call it before, or actually putting it and how do you call the, I forgot the word, actually, okay, so if you actually before disassembling the baby stroller and put it into a trunk, check if the baby is not in the stroller.
Someone
I
probably did that
recalled
once
it
on a
was a
plane.
famous American case for it, and in Europe it was a running joke. It was a running joke here, but anyway, you need to keep in mind that there are people for this. There were very little accidents in outer space because the most of people who went to the outer space were highly trained crews, were astronauts mostly, and scientists who were prepared. And it's not like, for example, like everyday person can actually go on a boat, go on a plane, go on a bus, and so on, and they don't need special training. But outer space is quite different.
Well,
And
I
if we
mean,
make
I would say that's only because we're in a situation where we don't have those people, right? If we did have those people going to space, then you would probably build systems a little bit safer, and you'd probably get them to sign, you know, all these contracts to limit your liability.
liability, insurances, and so on.
Yeah.
Yes, but also there, outside of technical safety, you also need to have some legal safety and legal precautions. Because, for example, that is why I'm against what is referred to in the Moon Agreement as treating everybody on the Moon as an astronaut. I don't recall which paragraph it was, but it was that everybody is should be treated as a moon, but mostly for the reason of safety. An astronaut in the meaning of as far as I recall, the Astronaut Rescue Treaty, but I can be wrong. But there were some descriptions and some papers which were which were speaking about the treating of the lunar dweller or the lunar tourist as an astronaut, in the same way as an envoy of mankind, and so on and so on. And the envoy of mankind, the astronaut, actually has a diplomatic status, and under the Article 12 of the OST, they can enter any facility on a reciprocatory basis. What, Idil?
I think we're oh, sorry.
No, go ahead.
I was going to say, I think it's time to wrap it up because we have the keynote speech starting now.
Okay.
Idil, did you have something to say?
Actually, no. I just think that the people who are not specialized so much cannot be allowed to enter any special facilities.
Yes.
That's all.
Yeah, I fully agree that. Well, I'm not against tourism, but I'm against those people becoming danger to themselves and others.
Yes, indeed.
How many people have fallen off the Niagara Falls while making pictures?
I'd say it'd be a lot, right? I'd say particularly before they put fences up.
Yeah, those fences are there for a reason.
All right, well, let's wrap it up. Thank you, everyone.
Thank you.
Thank you, everyone.
Hey.
Nice to meet you.
Thank you.